Good morning. Today, the judgment which I am going to discuss with you helps two ways. Number one, those who are appearing and preparing for examination to understand the contractual obligations, wherein a clause was available that is called force majeure, doctrine of force majeure, by which you can uh, claim that the default of performance of contract was not possible or feasible due to this force majeure. The another aspect was nowadays the new development was this solar power project. The government and the electricity board authorities are entering into contract with companies and individuals. The contract is called a power purchase agreement. By that, they have a contract allowing you to produce solar energy and supply to the electricity board at a agreed cost. By this judgment, go through the entirety of judgment, you can understand what all are the classes of Electricity Act and code which enables you to draft petitions, etc., etc. The appeal under Section 125 of Electricity Act is equal to 100 CPC, where we prefer second appeal. Now you see the judgment AR 2024 Supreme Court 4486, AR 2024 Supreme Court 4486. This judgment, Bangalore Electricity Supply Company Limited, Bangalore Electricity Supply Company Limited versus Harahalli Solar Power Project LLP and others. Here the village peoples, there was a few companies constituted for production of power by solar project, and there was an agreement that is called power purchase agreement that was entered into, and they could not complete the contract or commissioned date. Commission of, that means starting producing electricity by power project could not be completed because force majeure clause. What all are the grounds they have stated was when they applied for conversion of the land from commercial, from cultivation to commercial, and approval and so many things that could not be completed. Therefore, the KERC, Karnataka Electricity, seems to have imposed certain fine amount, and they have commissioned a committee for understanding the for considering the reasons for delay, but that was not accepted as per several code provisions, and therefore APTEL was introduced for appeal against the KERC order. That APTEL has passed an order stating that these companies have substantial evidence to apply for a force majeure clause. Therefore, the APTEL has granted extra time and also interfere with the reduced payment of tariff, and therefore it went up to Supreme Court. Supreme Court has rightly held that the order passed by the APTEL was good, and the ratio was, they say this is most. The Supreme Court Appellate Court is where they should allow freedom to a statutory regulator and tribunal to develop sectorial laws through a principled and consistent approach, and held that this APTEL was followed that directions. Therefore, the appeal preferred by Bangalore Electricity was rejected. Because I can't go through and read the entirety of judgment or important paragraph, because this is being watched by young juniors also. So juniors should understand by this ratio that what is doctrine of force majeure. Which major? Force majeure means unforeseen events like tsunami and corona. All these things are there, and departmental lapses. So many things are there. Kindly go through for others you must go through the judgment deeply to equip you with one more a feather of another wing of department to practice law successfully. Best